Trademarks are usually words or a logo or a slogan, and they're used to distinguish your organization from those of other people. So Canadian Cancer Society is a trademark. Coca-Cola is a trademark. And it has to be something distinctive, something that distinguishes you from the rest of the pack. So calling yourself a grocery business, that's not a trademark, that's what you do. A trademark is your name, so Loblaws would be the trademark. And it can be a very valuable business asset. And the next slide, I sort of go over some of the values, some of the top 10 trademarks by value, how much they're worth. And I actually updated that list this morning for 2009, and surprisingly it hasn't changed all that much from one you have, which is from 2007, although Google is now on there as number 7, and Mercedes has dropped off. And I imagine Toyota is probably not worth as much as it used to be anymore either, but they're having their issues. But these are all examples of very big trademarks that everyone will be familiar with. And obviously, if you see Nokia or whatever on a phone, you'll know that it's by that company. So that means you can distinguish that person's products and services from those of others. So you probably have trademarks that you're using in your businesses and maybe not even aware of it, but most people do have trademarks. But there are other types of intellectual property. There's copyright, which protects original works. And copyright it's the exclusive right to produce or reproduce that. So if you have copyright over something, nobody else is allowed to reproduce that without your permission. And copyrighted works tend to be literary works, books, dramatic works, plays, movies, musical works, compositions, artistic works, sculptures or paintings. So. But they can also be sort of business type works. They can be business plans or computer programs. A lot of you might have training manuals or publications that you've developed in your industry. As long as it's original, then copyright protection would apply to it. And copyright protection arises automatically, which is one of the reasons I'm not going to go into it so much later on, because you get it automatically upon creation. So you don't have to register it for copyright protection to apply. And it lasts usually for the life of the author plus 50 years, although there are differences depending on if it's a photograph or if it's not being published. There are little nuances, but in general, that's how long it lasts. So, so the copyright, if you want to register copyright, that's always a good idea, but it's not required. And if there's a CPO site, I've given you a link to that, where you can go and you can register it yourself, and the filing fee is $65, and it's pretty easy. And the benefit of registration is proof of your ownership, obviously, and it means if you sue someone, they can't claim that they didn't know you owned copyright because it's there on the copyright register, so they can't claim innocent infringement. So it's not a bad idea, but frankly, most of my clients don't bother registering. It's only if you're really in the artistic business that you go to that trouble. And there's also no requirement to mark your work under the Copyright Act. There used to be a requirement where you have to put C in a circle and the year, the name of the owner and the year of first publication. Now that's no longer a requirement, but people do still do it, and it's a good idea because it puts people on notice of the fact that you're claiming copyright in something. And the other thing that copyright applies to that a lot of people have is a website. So the look of your website, the look and feel of your website, the colors you've used, the positioning of the logos, that can be subject to copyright protection, and that's something that sometimes comes up. People say, my competitor has copied my website, people will go to it, they'll think it's mine. So that's another area where copyright comes into sort of real life. There's also a type of intellectual property called a patent, which most people have probably heard about, and that protects new and useful inventions. So for most of your organizations, I don't think it's going to be something you're going to need to think about, but it protects things like a product, a door lock will be patented, or a chemical composition, or an apparatus, like a machine that will make door locks, or a process, or an improvement of any of these things. So it has to be novel, it has to be useful, and it can't be something that was obvious. Although frankly, a lot of things that seem to get patented, you think, damn, why did I think of that? It's so obvious, but there's a sort of legal definition of non-obvious. And patent protection lasts for 20 years. The point of patents is you're supposed to put it on the patent register. Everyone can see what you've done. They can use that technology to try to develop new things, but they can't actually sell their products that they've developed using your patentable technology without a license. So it encourages people to share their discoveries, but it gives them a way of protecting them at the same time. There's also trade secrets, are sort of associated with intellectual property. And these aren't anything that you actually register. These are things that you might know in your business that are secret from other people and are useful, such as, you know, the secret formula for Coca-Cola. The thing about a trade secret is it is kept secret. There's no putting it on a register. People aren't made aware of it. But you do have to make sure you protect it contractually, because once it becomes known, that's it. It's gone. It's no longer a secret. So it's really only valuable as long as it is secret. And it doesn't have to be something that's really, you know, big. Anything can be a trade secret as long as it's kept secret. So a lot of companies will have non-disclosure agreements when people work for them that they have to sign, you know, saying anything they see while they're here is supposed to be kept confidential, and you know, things that you might have that might be you might want to keep secret as a donor list or a customer list, those sorts of things, business plans. So, but there is no sort of way to register that. It's just protected by contract. And then there's a type of thing called industrial design, which is a useful article, but sort of it protects the shape of the article. It has to be a distinctive shape. So for instance, the Coca-Cola bottle, the little cute one that they've used for years and years, that's an industrial design. The shape of a chair, if it's really unique, like this wouldn't be unique, it's just a chair. But there's some chairs that you've seen, as shown on my slide, that can be a bit more distinctive. So it protects the shape. A lot of car companies have registered the shapes of their cars as an industrial design. So it's not one of the, I don't do industrial designs, it's not that common, but certain companies have things that they want to protect by industrial design protection. So one thing I'm talking about is a trademark isn't the same as a trade name or a business name or the name of your corporation. And a lot of companies make the mistake of incorporating under a name or registering a business name, which is like, you know, like Travelings could be a business name, or Thomas Cook, thinking that's all they need to do. And the trade name, the trademarks, the registers that help you register things like business names and incorporated name, they don't do a lot of searching when you file. They don't do a lot of due diligence. They say, okay, sure, if it's not exactly the same as something else that's here, you can have it. So people think, oh, good, that means I can use it and, you know, throughout Canada and protect it. Well, you're really not. It's not enough. You can still have someone who owns a registered trademark come after you, as I've done on behalf of many of my clients, and say, you can't use that trade name. It's confusingly similar to our trademark. And they'll say, but I registered it as a business name. You say, well, too bad, you know, you didn't look at the trademarks register when you did that registration. It's, you know, similar, it's not the same, but your business is the same. People are going to be confused. So the point of this one is just don't think that just because your company has incorporated under a name or has registered a business name that they actually have protection. Trademark protection is really the way to go. It's the best thing that you can do. So if you've determined that you might have something that's a trademark, how do you go about protecting it? Well, first of all, it's important if you're choosing a trademark sort of from scratch, for instance, choose something that's distinctive. A lot of my clients come to me and say, you know, they might be, say, a car company, and they want to register best cars in the world or something like that. Well, that's not going to be a good trademark because it's descriptive, everyone's using something like that. So the best types of trademarks are ones that are actually made up words, like Kodak or Exxon, you know, words that have no meaning in the English language other than the fact that they're a trademark. Novartis is actually a made-up word. They combine sort of some Latin words. And so if you've got a trademark like that, that's a word you've actually made up yourself, that's going to be the best. It's going to have the best type of protection. You shouldn't choose a trademark that's primarily a full name or a surname. That won't be registrable. And the point, you do want to choose something that's registrable, that you can actually register, because then you get the protection of a trademark registration. And I'll go into what that means later on, you know, for you, but it's a good thing to have. So don't choose something that's the full name or the surname, although if you've used those for many, many years too, you can sometimes get those in, like Disney obviously has become registered, but they're not the best ones to choose. And don't use something that describes what you do, or the product, because that's not going to be registrable at all. And even if you could squeak in a registration, you're not going to be able to stop other people, because they're going to want to use the mark to describe what they do too, if they're doing a similar thing to you. So the type of searches I normally do are, like Google obviously is good. I mean, it sounds kind of stupid, but it's a good way to do, you know, type in your name, see what pops up. But you should also go to the trademarks register, and you know, you can hire a lawyer to do it, or you can do it yourself. It's obviously I know how to do them better than you probably, but for people who are on a tight budget, you can still go to the SEPO site yourself, and the link is in the 5 Good Ideas, and look on the trademarks database and type in the word, and maybe type in some variations, and up will pop a whole list of people that have marks with that word in them, and you can click on them and see what they were registered for, who registered them, when they were registered. So it's a really good way of trying to figure out what's out there and avoiding people that you might be similar to. And you can apply to register a trademark well before you intend to use it too. You don't have to wait until it's actually in use. You could apply based on proposed use, which means if you're thinking of launching a certain product, say in 6 months, and you already have a name in mind for that product, you can apply to register it now, so that in 6 months' time you don't have the thing, oh, someone else started using it 2 months ago, shoot, if only we'd started using it earlier. We don't have to worry about that, because in Canada it's either the first to use or the first to file an application that gets priority. So getting your application in as soon as possible is really a good idea. And the trademark registration means you've got, you're providing notice to people that you're there when they do their searches on the SEPO site, and SEPO is short for the Canadian Intellectual Property Office. When they do their searches, they'll see you, so it deters other people from choosing marks that are similar to yours. And it also, under the Trademarks Act, if you've got a trademark registration, you have the exclusive right to use that mark across Canada in association with your wares and services. You don't get the right to use that mark for everything. Like, there's a registration for Lexus for cars and Lexus for orange juice. Like, you can't monopolize every product and service, but you do get the ones that are the same or similar to yours. So it's a really good thing to have. Because if you don't have a trademark, you can only get protection in that small pocket that you've actually used it. Say you've used it in Toronto, that your protection will be limited to Toronto. So if someone else wanted to open up a similar business in BC, they could do it. Whereas if you have a trademark registration, they wouldn't be able to do it because your protection would apply across Canada. Let's see. So after you've registered your mark or chosen your mark, you have to keep using your mark. There's a bunch of things you need to do. One of the things is continue using the mark as you've registered it. And I've got a picture of the little penguin here because there was a case of the corpulent penguin, they call it, where someone registered the little chubby penguin guy that you've got on your slide. But over the years, the look of that logo changed. He became skinnier and skinnier and skinnier until finally he was so skinny that someone applied to strike that registration. Like, people can do that. They can attack your registration and seek to expunge it. And they sought to do it on the basis that they were no longer using a registered mark. The mark they were using was so different looking that it wasn't the registered mark. So the penguin owners, Munsingware, were successful in saying, oh, come on, it's a penguin, the dominant features are still the same, and they were able to maintain their registration. But it was close, and the judge, they had to go to court, and it was a big deal. So the moral of that story is, when you've registered a logo or a design, make sure you keep using that logo or design as it is. And if you want to use a different one, then you've got to do a new registration, really, so, because your protection extends to that particular design. And trademark marking, this is something I get asked about a lot. When should I use a TM? When should I use an R in a circle? Well, there's no laws about this. It's not the law that you have to use R in a circle or TM, or that you can't use it. But there's sort of a custom in the industry, and it's a good idea to put people on notice. So what I say is, if you've got a trademark that's not registered, use a TM beside it. If you've got something that's not a trademark, don't use a TM. But if you've got something you think is, you could appropriately claim as a trademark, it's a good idea to put a little TM beside it. If you've got something that's registered, then put an R in a circle beside it. And it's also a good idea to have trademark notice. So you have something in small print on the bottom of your product or your manual or whatever saying, TM is a trademark of such and such, or R in the circle is a registered trademark of such and such. So, and that puts people on notice that you're claiming something as a trademark. And then the other thing to remember is, if you're going to let someone else put your trademark on their publications or on their website, make sure that you've authorized them to do so. But make sure, and it's called licensing. Make sure you've licensed them, and that's preferably in writing. But if not, some sort of written, like preferably a license agreement. But if not, any sort of written record of that is useful. Something to show that you're not just letting everybody use your trademark without any sort of control, but you're controlling who can use it, what they're going to use it on, how it's going to be used. It's a good idea from your business perspective, just to make sure that your marks aren't out there, being used by all sorts of people without your consent. And the last thing is take prompt use against unauthorized users of your marks. If you find other companies using something similar, even if you haven't registered it, you should consider sending them a letter and putting them on notice of your rights and asking them to stop. I caution you against the letter, though. Before you send a letter, just try to do a bit of due diligence and make sure that they weren't using it before you, because as you remember, it's first to file or first to use, and you don't want to send a cease and desist letter to someone saying, our marks are confusingly similar, stop using it. And then they write back to you and say, well, we've been using it for 10 years, you've only been using it for 5, so you're the ones who should stop. So you make sure that you do have prior rights, but it's a good idea to make sure, keep an eye on the marketplace and just see who else is doing stuff. Because often you find if you've got a good trademark or a successful program, people will start copying you. And you've got to keep an eye on this. Otherwise, if other people are using similar things and you've done nothing about it, it's the same as licensing your mark without, inappropriately. It's just, it becomes generic. So then you can't protect it anymore.